Good morning to everyone. This is Dr. MRK Prasad, Dean Faculty of Law, Goa University, also Principal of Silgankar College of Law, Panaji, Goa. I hope you have learned a great deal of access to justice from previous mocks modules, and you have learned a lot that legal aid is one of the tools for the access to justice, and we realize the importance of legal aid as a tool to improve the access to the justice to the masses. Therefore, the last we are having 3 modules again on access to justice through legal aid, and we have already learned how the access to justice was promoted by the legal aid developments prior to 1970. To learn a great deal about legal aid, how it brings access to justice to the masses, we had 3 modules kept on that. You have already learned 2 modules on legal aid. One is the developments prior to 1970. The second module focused on the developments from 1970 till 1976. The third module, which I am presenting today for all of you, is on how the legal aid developments provided access to justice after 1976. So today we would be focusing mostly on the developments that took place from 1976. What is the object of this module? The basic object of this module is primarily to analyze the experts committee report on national judicature, equal justice and social justice. And also, after focusing on this, we would be also looking at the 1980s. After focusing experts committee report, we would also looking at the suggestions made by the committee for implementing the legal aid schemes. Then after that, we will see how the recommendations of these both committees was transformed into a national legislation. So by undergoing these 3 modules, I would say the 3 components of this presentation, you would really appreciate how the legal aid, which has started as schemes from the state, has become a statutory obligation from 1987 onwards. The access to justice concept was formally introduced in India by the Bombay Legal Aid Society, as we learned in the first module, that is the developments before 1970, and subsequently the Bombay Legal Aid Society's recommendation. There were many other committees has made recommendations. You could see on the slide that the West Bengal Legal Committee, then 14th Law Commission has discussed a great deal of how the legal aid should be secured by the state. Then there are many other reports from different states, and then which ultimately lead to a constitutional amendment in 1976. The 42nd Amendment made it a directive principle of the state policy to provide free legal aid as an obligation on the part of the state. So the access to justice through legal aid has received a great deal of discussion, not only from the state but also from the academia and also the other stakeholders. However, one of the fundamental problem that was faced in implementing the legal aid schemes as suggested by different committees is one, the financial problems, and also the problem of no uniformity in India. Therefore, an expert committee was established in 1977, and the committee has given a report. We are looking at that the recommendations of the report of the expert committee, National Judicare, Equal Justice, Social Justice, and the committee recommendations, we would be focusing mostly on the uniform legal aid program throughout India, and also it looked the another challenge of how do we recognize this legal aid program and institutionalize this legal aid program in India. So the basic task of this committee is to uniform implementation of legal aid programs, and there were certain hindrances to achieve this. Therefore, the committee also highlights the need for statutory provisions making legal aid as an uniform process throughout the country of India. So after these recommendations were made, the recommendations were well taken by the state, the government, and this led to the enactment of Legal Service Authorities Act in 1987. However, due to certain reasons, this act could not be enforced immediately, and to identify these problems, there was a conference was called to make suggestions under the chairmanship of Honorable Chief Justice of India, and finally it has given certain recommendations. Though the recommendations were made, the act could be enforced only in the year of 1995. The post legal aid developments from 1976, I would divide into three components. One is the expert committee report, then the second one is the committee for implementing the legal aid scheme. The third one is bringing an enactment at the national level, the Legal Service Authorities Act. Okay. So let us talk about the first, the experts committee report that was submitted in 1977. As we already discussed, that the committee is focused more on how to implement a uniform legal aid program in India and how to raise funds. The financial support for the legal aid program is very much necessary. So the committee has focused not only on these two, but there are many other innovative recommendations were made by this committee. And the committee recognizes that India adopted democracy as a form of government, and such a democracy cannot survive without providing access to justice. And the active protection of the equal laws and the socio-economic equality could be achieved only through providing equal access to justice, and if it is not guaranteed by the state, which is actually a state responsibility, then the democracy would not survive. So therefore, the committee looks at that the access to justice is not only providing what we call legal representation at the free of cost, but also it looks at the heavy fees that are charged for resolving your disputes, and also the logistic hurdles and the early litigative finality. What I mean by early litigative finality is that the litigation cannot run for years. It has to be completed as soon as possible. So these are also part of the access to justice program. Hence, the committee not only looked at the uniform procedure for implementing legal aid, not only the financial assistance, but also the other aspects. That is the reason why the committee also felt that the theme of Panchayat justice must get a primary attention. That means the access to justice should come from the grassroots level. The committee was of the view that there should be a considerable reduction of rates of court fees. As we already discussed, that it is not only providing legal representation at free of cost, but even the court fees should not hinder the people approaching the court for justice. And a blanket exemption from the payment of these fees in case of anybody who is under the poverty, below the poverty line, was also advocated by this commission. That means if a litigant is declared as a person below the poverty line, he should be totally exempted from paying the fees for his litigation. Then the committee also looks at the illiteracy, backwardness, the socially suppressed and geographically handicapped people also should be provided with the legal aid. And it also talks about providing free legal aid for the families of Jawans. And it also identified several other categories who are entitled for the legal aid, for example, women, children, even the minorities, both linguistic as well as religious minorities, who are entitled for this free legal aid. Then the most important aspect of this committee and what makes this committee different from the other committees and the reports of other committees is the focus of this committee on the role of non-governmental organizations and more importantly on the role of the law colleges, the students of the law colleges. So, the committee has spent a great deal of amount on how to use particularly the law school students in providing free legal aid, and also it enumerates several advantages of involving the students in the legal aid program. Then it also talks about the voluntary wings of the bar associations who are willing to take the legal aid programs to give free, and it says the law schools may fulfill a useful function in providing the legal aid program. The committee also looks at the expenditure of the legal aid, and it says that any amount spent on the legal aid should not be looked at as a charity. What it says is that every rupee paid or spent on the legal aid, it is money that is spent on upliftment of the poor and to provide justice. Therefore, the amount that we are trying to spend on the legal aid, or the idea that legal aid could not be achieved because of its expenditure, is not correct. The spending of the money should not be looked at as a welfare. So, what the committee says is money that was spent on legal aid shall not be treated as a waste of money. It should be looked at as that money spent on the legal aid is for the upliftment of the poor. Further, it also says that the committee proposes that in every law college you should introduce the legal service clinics and make this legal service clinics as part of their curriculum. That's a very, very important suggestion, that make the legal aid clinic as a part of the curriculum so that the students will get a academic credit for doing the legal services. It also states that there is a need to reform the system of legal education in this direction and make the legal education poverty oriented and multidisciplinary, so that the more number of students would be encouraged to join in the legal aid clinics. And it also says that it is very, very important that there should be a university and a law college scheme for conversion of the enthusiasm of the law students into the potent source on behalf of the people in indigent. That means there should be a constant encouragement for the universities and the law colleges to adopt legal aid clinics in their curriculum. And also it says, the committee report says that the participation of the law students in legal aid clinics has different benefits. The advantage is that they are being students, the legal services could reach to the people much effectively because the number of law students are more. Second one is, it could reach to the masses at a minimal cost, the most importantly, because this is one of the reasons why they say that the legal aid is not taken off in India is because of financial difficulties. So, further it looks at the involvement of the law students at the early stage would develop a deep sense of personal responsibility towards imparting justice. That means the law students who undergo these legal aid clinics while they are students would create them socially conscious lawyers, and it would create a barefoot lawyers which are necessary for the country. And it also says that the National Council of Legal Service Clinics or the State Council of Legal Service Clinics should subsidize its working and making suitable grants to the universities and the colleges who are running these legal aid clinics. And the most important recommendation made by the committee in this respect is that the amendment of Advocates Act to make a suitable recommendations for allowing the law students to practice and represent the clients while they are law students before the court. So, this is practically very important suggestion, because Advocates Act doesn't allow neither the students nor the faculty members to represent the clients, even in case of pro bono cases like free legal aid. And the committee also gives a detailed provisions on whom we should allow, how they should be allowed. For example, it says only the third year law students, that means the final year law students, that time there are only 3 years course, there is no 5 years course. Hence, the final year students should be allowed to participate in the legal aid service clinic, and they should be certified either by the dean or by the principal of the college to entitled to appear before the court. That is the second condition. And the third condition is the representation shall be supervised by the lawyers associated with the legal service clinic. That means the apprehension that the law students are not competent enough could be well taken care by the lawyers who are guiding them in this aspect. And also a special approval from the judge in whose court the students are going to appear also necessary. So the recommendations given by the committee in allowing the students in representing the clients is found on it was found on really and good reasoning. And after dealing at great length on the law students, it also says, the commission also says that it is necessary that there should be a national council of legal service clinics at the national level. And it also proposes that a similar council should be there at the state level. The purpose of these two clinics is that to promote the movement of setting up of legal service clinics, and also to give guidelines to the universities and the colleges how to run their clinics, train the students and work with the clinics, establish a working relation with the law teachers and academicians operating the legal aid service clinic to give them support, strengthen them. And in addition to that, it also insists that a proper research need to be done on how these legal aid schemes are working in India. The second recommendation that comes from the committee is that to bring a uniform pattern in the legal service program. It says that there is a need to bring a uniform pattern throughout the India, but it doesn't mean that there should be only one method of providing legal aid. It says though you have a uniform method or a program for a legal aid in India, it also says that it is subject to the modifications, changes that are required to suit to the local conditions. Therefore, we will have a uniform pattern, but at the same time, it could make a suitable changes to meet the social conditions of the local people. And it further, it says the committee is also of the view that the ultimate responsibility of the success of the program would be on the national authority. Further, the state national authority would also be responsible for the state boards within the area of their representative jurisdiction. And the national authority, with the previous approval of the central government, can make several schemes for the delivery of legal services. It also makes the provisions relating to legal services for the protection of interest of minorities. The national authority may also frame model schemes for guiding the state boards. And further, the committee also says that there should be a High Court Legal Service Committee at each High Court, and a similar lines there should be a committee at the Supreme Court level called as Supreme Court Legal Services Committee. And the national authority and the state board should exempt from the liability to income tax and wealth tax. That means if any money that has come to these boards should be given an exemption from income tax. Now, when it comes to the role of the legal service programs, it says what kind of legal services program should be adopted in India. There, the committee cautions us, because it's very quite natural for the human beings to compare with other places how it is working. And mostly what we do is how this kind of legal service given in foreign countries could be looked at it, but it says blindly adopting their pattern in India is not advisable. So you may look at it, but you have to see how that program would be suitable for Indian condition. And also it says that the traditional legal services program, which is basically giving a free representation before the court when there is a dispute pending before the court, would not be sufficient, because the problems are different in India and there are many cases where litigation is not the answer. Therefore, the legal services authorities created under this report suggest that their role is not only providing free representation in the court, but also the at the grassroots level that you should provide other services like giving advices, etc. And it also talks about it's not only providing representation in the court, but the program also should aim at prevention and elimination of various kinds of injustices. Then it also says that you establish Nagarik Salaha Kendra. The Nagarik Salaha Kendras are primary responsibilities to provide advices to the citizens generally, and these advices not necessarily on legal issues, but it could be on any other entitlement issues for the purpose of dispensation of equal justice. Further, it talks about a great deal on how the legal aid services should be provided to the workers, and particularly this scheme should focus on settlement of industrial disputes. Another key recommendation made by this committee is how to use these public interest litigations or the class representative suits for providing justice. That means the legal service authorities also should focus on bringing public interest litigations or class suits for protection of the rights of the oppressed class. They had given a few examples on where this could be used. For example, environmental law, pollution, drug adulteration, fair wages issue, or the discrimination on the basis of untouchability, equal wages for women. There are many other areas that the committee has recommended where the public interest litigation could be suitably used by these services. And to continue further, the committee also spent a great deal of amount on research, and the research is one of the key ingredient for providing legal aid, because through research they could look into how these legal aid schemes are working, how the several acts under which the legal aid is now mandatory are working. And for this purpose, the committee says that the authorities are created under the legal services should have a liaison with the law commission and the law ministry at the central level as well as state level. And it also suggests that we should establish a directorate possessing the legal knowledge with the experts in various fields for carrying out this research. Now, while explaining what is the role of the research in this, it says there should be 5 divisions under the research department. The first one is the statistics, second one is socio-economic problems of the indigent and disadvantaged group, third one is litigation research including test case litigation, fourth one is legislative research, fifth one is performance, audit and evaluation. So these 5 concepts were stressed by the committee, and it says the legal aid organization in each state should have a directorate of research with statisticians, sociologists and a lawyer to assist the director in performance of the 5-fold functions of the research and evaluation outline. That was just now we have discussed. And also it says it is better to develop a common research designs so that it could be effectively used in different parts of the country. And another most important aspect of this committee is legal awareness programs. And keeping in view the amount of illiteracy in the country, and if you actually talk about legal literacy, even many of the literates don't have the legal literacy. Therefore, a great deal of time should be spent on legal awareness programs, educating the people about their rights, their entitlements, their liabilities, etc. For this, the committee has given an elaborate scheme how these legal awareness programs should be conducted both at the national level and also the state level. And it enlists the services and voluntary, it requires a great deal of involvement from the Bar Council. It requires involvement of universities, colleges, teachers, students, social welfare organizations, NGOs in making the public aware about their rights. So the committee stated that the judiciary must play a very important role in this regard. Further, it says that the state should ensure that the laws that were made by the state must be understandable and available easy to a layperson. So therefore, it recommended that the Bar Council of India should make rules to call its members to conduct these legal awareness programs periodically. And also it talks about it is an obligation on the part of every legal graduate to join in the bar, spend at least 6 months as an intern in any legal service organization. And any legal graduate joining in such internship should be provided with 250 rupees per month as a honorarium. And only a legal graduate who completes this internship would be entitled to enroll as an advocate. So the another concern that was raised is, if you are going to provide free legal aid, would it result in docket explosion? What I mean by docket explosion is the number of cases that would increase in the courts because you are getting a free legal aid. As you are not going to spend, you may file frivolous cases in the court. There is possibility. There is a reasonable apprehension that the free legal aid may result in numerous litigations in the courts. So to avoid such kind of thing, again the committee has spent a considerable time and mentions that the person who applies for free legal aid should satisfy 3 tests. That is means test. That means the government is going to fix the ceiling on the income. Only the people who are below that income can entitle for filing asking for a free legal aid. And the second one is the prima facie test. The prima facie test says that when a person, even though qualified under the means test to get a free legal aid, but still the legal service authority which is suggesting that free legal aid should be provided or not should be satisfied that there is a prima facie case for giving free legal aid. That means there is a reasonable case in that. And the third test that propounded by this committee is that a reasonable test. What the reasonable test says that the reasonableness of the suit for availing the benefit of free legal aid. That means it is the only way to get the required remedy. So these safeguards will go a long way in reducing the frivolous cases before the court. Further, the committee also says that establish a conciliation cell. Therefore, whoever comes for free legal aid first will undergo to the conciliation proceedings, and if the conciliation proceedings fails, then only that will go to the court. Then, so that would basically would prevent the misuse of legal services programs. And it also talks about the financial assistance for legal aid program, because that is one of the concern for the committee, how best we could get funding for these legal services. It has given a number of options. The first option is the state must provide a specific budget allocation, like how it is providing for other social welfare schemes. Similarly, a legal aid scheme, they should provide a specific budget. Then second one is revise the existing pattern of court fees. And also it says that the court fees must not become a tax on the litigation. So how much the court fee should be charged, it need to have a revision. And it talks about legal aid stamps. A very innovative step that suggested by experts committee is that you create 2 kinds of legal aid stamps. the legal aid stamps of 1 rupee or 50 paisa equivalent to 50 paisa, and on every wakalatnama 1 rupee legal aid stamp should be affixed, and for all other you affix 50 paisa legal aid stamp. So, this money could be deposited to the legal aid services, and from that money the free legal services could be provided to them. And also it also talks about impose some cess payable on every person. The cess will be for the purpose of getting more funding for the legal services authority. Then the cess should not be imposed more than 100 rupees per case, and also it talks about where the cost was awarded by the court, the cost should go to the legal service authority. Similarly, when there is a property has attached, the property attached, the state board of legal service should be authorized to recover this property or money decreed in favor of legally assisted person, and certain percentage of that could be retained by the board. So, if you look at the report is very comprehensive and made several innovative recommendations for implementing the legal aid, and this report became a base for several other initiations taken by the state after 1976. Now, after the recommendation of this committee, the central government has established the Committee for Implementing Legal Aid Scheme. It was established in 1980 and it was established under the chairmanship of P.N. Bhagwati, Judge of Supreme Court of India. The SILAS, in short form, evolved a model scheme for legal aid programs, and the duty was imposed on the chairman to monitor and implement the legal aid programs on a uniform basis in entire India. The SILAS was financed by the central government, and when it was felt that there should be some statutory legal service authority at the national level and the state level and the district level. Therefore, finally, this led to the enactment of Legal Services Authorities Act in 1987. As I discussed in the beginning, though the act was made in 1987, there were certain difficulties in implementing. Therefore, a conference was called to iron out all these problems. The conference was held under the chairmanship of Honorable Chief Justice of India. Justice R.N. Mishra, who was then Executive Chairman of SILAS, moved the motion and made certain discussions at the conference, made a proposal to amending the act. Consequently, a bill was framed to amend the Act 1987, but for several reasons this bill was not passed in the Parliament. However, in 1987, Act was made enforceable from 1995, and later in 2002 an amendment was made to this act. So, to conclude today's discussion, the suggestions made by the experts committee played a very important role in giving a shape to the existing legal aid scheme in India, and that is the prime reason how the Legal Service Authorities Act was passed in 1987. Now, the Committee for Implementing Legal Aid Schemes further regulated the uniform implementation of the legal aid program in India. So, both these reports have made what we call as a distant dream of providing free legal aid as a reality today. So, the existing Legal Service Authorities Act is a result of these committees. So, I hope you have learned a great deal about legal aid in post 1976 developments. However, if you have any kind of questions, any further clarifications, we will be happy to help you. Please join in the forum and write to us through emails. We will get back to you and we will provide you further readings. Thank you.